Good morning, everybody. I'm Tim Edson. I'm the Circuit Public Defender. Y'all doing okay today? Let me tell you why you're here. For those of you who are not our clients, and then for our clients, this is an arraignment day. Now, some of you have contacted us, and some of you have called our office about your case. Some of you did not make contact with us. But this is what we call the arraignment, okay? This is pleas of guilty or not guilty. There won't be any evidence presented. There won't be any arguing about your case today. And the judge, when he calls your name out, he's going to ask you, what are you going to do? Okay? And what he's referring to is a lawyer. You know, what you're going to do as a, for representation. Now, if you want public defender services, if you want our services, we need for you to fill out an application. That's required. We need you to do that as soon as possible. You would tell the judge, I would like to speak to the public defender. What we're going to do is when they go through the calendar, okay? If you've already talked to us at our office, that's fine, but we still need for y'all to go down to the other courtroom after the judge calls the calendar. The reason for this is because normally the state will relay some offers today in your case. It doesn't mean that we think that you should take it, but we do have to relay any offer or anything the state tells us to the client for your acceptance or rejection. If you, after consultation with the lawyer and reviewing the state's case, you feel like it would be in your best interest to take the plea, you can do that. If you feel like you want a jury trial because you're not guilty, that is fine too. You should never plead if you're not guilty of anything. So we will talk to you more after we call the calendar and we can talk to you in private, okay? Instead of talking to you right here. Does anybody have any general questions about the procedure here this morning? Yes, sir.
All right, I need y'all to pull together just a little bit. Everybody needs to raise your right hand, please. You solemnly swear firm testimony about to give before the court this matter is the truth, the whole truth, and nothing but the truth, so help you God. Got an trap Bible?
I do.
All right. Thank you. Made all your hands. All right. All right, these next questions I'm going to address to all seven of you collectively, but then you can answer individually and out loud. Now, do each of you understand that you have the right to plead guilty, plead not guilty, to stand silent, make no plea at all? Do you understand that?
Yes, sir.
Do you understand that if you plead guilty, you will be waiving giving up valuable, legal and constitutional rights? Do you understand that?
Yes, sir.
All right, listen carefully, I'm going to go over those rights with you. Each of you, if you would plead not guilty, make no plea at all, have the right to a trial by jury. At that trial, the state will be required to prove your guilt beyond loss by repeatedly striking you in the face with a closed fist, all contrary to law. You understand? Count one of the accusations. And speak loud, sir.
Yes, sir.
And how do you plead?
Yes.
Guilty. All right, what's the factual basis for this plea? General conditions of probation. That recommendation anticipated, Ms. Reed?
Yes, sir.
All right, now we'll follow the negotiated plea. We address the reason to give you a plea of guilty to the misdemeanor offense of battery in accusation, count one of accusation 13R226. That sentence you serve 12 months in the Chris County Jail later, serve that sentence on probation. Advise you pay a fine in the amount of $300 plus cost and surcharge for 16 hours of community service. And have no contact with the victim in this case. Chris County, Georgia, you did unlawfully take any merchandise, being the property of the country store with a value of less than $500 with the intent to appropriate said property to your own use without paying for the same. You understand the accusation?
Yes, sir.
Now you plead.
Yes.
It's a factual basis beyond what's stated.
It's what stated. It was all about $5 worth of candy. She didn't know why she did it. Wasn't complaining about it.
March 2013 in Chris County, Georgia, you did unlawfully take cable splitters merchandise being the property of Walmart and retail establishment with a value of less than $500 with the intent to appropriate said property to your own use without paying the same, all contrary to law. You understand the accusation? How you plead? All right, what's the factual basis beyond what's stated?
Just that the value of the merchandise taken was $19.35. That was not recovered.
Anything you want to add, Ms. Denson?
Judge, I reviewed the evidence with both my client and his father, and we agree that the factual basis
I'll accept the plea. I find it free and voluntary late. I'll find the factual basis of the plea. Please therefore accept the court place upon me. Mr. C. Brooks.
Yes, sir.
Accusation 13R222. Charges you in count 4. As follows: district attorney for the employee of the district attorney has assistant Georgia charges accused you of the possession of less than 1 ounce of marijuana alleged on the 19th day of March 2013 in Chris County, Georgia. You did unlawfully possess less than 1 ounce of marijuana in violation of Georgia Controlled Substances Act, contrary to law. You understand the accusation?
So, yes, sir.
How do you plead?
No contest, sir.
No contest, and no up intended.
Yes, sir.
All right. State, accept that plea?
Yes, sir, we will.
All right.